a friend of the ADR skills program at New York Law School since it started. He's extremely generous with his time and with his caring, particularly because his job as the chief legal officer of the American Arbitration Association and the International Center for Dispute Resolution is pretty demanding as it is. And this week in particular is arbitration week, so he's going moderately nuts, and yet he found time to spend this evening with us. So I hope that you'll join me in thanking him for coming. Eric.
Thank you, Peter. And it's always nice coming to visit you and the school. It is a busy week. There's a lot of arbitration programming going around right now in New York. And I don't know how many of you are following that, but it is New York Arbitration Week. And this happens once a year at this time of the year. And it's when New York as a venue really tries to show itself off. And so you have most institutions, most of the leading firms that practice in that area, either hosting programs or events. So it's actually a great week to talk to people and to collaborate about everything that's going on in our field. Peter was mentioning what I do at the AAA, and I was saying I'm always busy. I've been in this position for a long time. It is every day is fascinating. Every day is different. And Peter said, well, why is that? Why is that the case? And despite the fact that arbitration is a relatively the legal field. Now, it's not just really arbitration. I'll talk a little bit about innovation, how we see things changing, but it's a pretty conservative area. You don't see dramatic movement from time to time. If you just think about virtual hearings, that technology existed for decades before the pandemic. It took the pandemic to force everybody who is involved in the dispute resolution process to start using that technology. And of course, now we all rely on it. And we're going to have additional changes like that. We're going to have more changes. It's going to be it's not going to turn this process on its head, but it will be different. So again, thank you for inviting me, Peter. Today's program, at least as the topic is suggested, is a little bit of a challenge because it's open-ended and there is so much that's happening in the field, right? So what do you talk about? On the other hand, it's easy because the exact same reason. There is so much taking place. There's a lot of anticipation about changes in the field. And just internally within the American Arbitration Association and our international division, we're pretty bullish on the future for dispute resolution, for arbitration. There's a lot of problems in the world. We'd love to be able to say that we could come up with whatever magic is going to be needed so that there isn't any more conflict. But in fact, we're not there, and we're probably going in the wrong direction, but we think that there's much better ways of doing things and handling things, and we're really regrouping on those efforts. So I'm going to touch on 4 sort of main topics, but I want to say, and this is also to everybody that is online, I want to hear what questions you have as we move along, as we're discussing topics. If you all have, any of you have questions, please enter them into the chat. Any of you here, if you have questions, please raise your hand and I'll grab them and I'll try to answer them best I can. But I really would prefer that this is more of a conversation. So I'll be talking about what we are working on right now, what we are focused on organizationally, what we think is important, why this is maybe a little bit of a turning point in our field and for the legal field more generally. I'll talk about technology and AI, which is so cliche to say that, right? Isn't that, can you get out of a program without saying, this is transformational, things are gonna be so different. It's going to put you out of work. It's going to create work, right? We don't really know how this is going to end. Nobody knows how this advancement is going to change the field. There's some things we've seen already, but I'll talk about at least how we are addressing it. I'll say a couple words about legislation and regulation because that's something I spend a lot of time thinking about and worrying about and acting on. And even when things are quiet, seemingly to the rest of the world, there's always things taking place. And there are certain aspects of our work that will always be controversial. And then I am happy, I'm going to spend a few minutes talking about our foundation, the AAA ICDR Foundation. And I just want to make sure I'm sort of making a point when I do speak to take a few minutes to talk about the work of that great organization. That's part of what we are. So the first topic, what is happening at the AAA and the ICDR? And as I say, we are busy. We're celebrating our 100th anniversary in a couple of years. And we're already getting ready for that. It's going to be, we hope, a big celebration. And we're planning events, things around the country, probably around the world. I was looking through a binder earlier today, a letter from Herbert Hoover to one of our presidents. And, decades ago, there's all these little sort of nuggets of history in the AAA. But it's got this rich tradition, so we want to be able to celebrate that. But we also want to make sure that this is a celebration of what we're doing going forward. We don't want it to be the AAA museum that we're establishing as much as we want to establish a view of our path forward. But it's also busy because we've got new leadership. We have a new president and CEO. She started in February. She's a former Chief Justice of the Michigan Supreme Court, Bridget McCormick. She did that for 10 years. And before I actually knew who she was, I knew as a former judge, right? We're all learning a little bit more day by day. Again, even her identity. I was wondering about, what the impact of having a former judge would be running the organization. And even when I learned about her background, I thought having somebody who's a Chief Justice would be somebody who would be really interested in black letter law. I manage the legal department. I thought she'd be really interested in the litigation that we deal with. We deal with a lot of litigation. I'm not actually going to focus on that so much today, but there's a lot of collateral litigation that arises out of the cases we administer, and we get caught up in that. But that is not where she spends her time. She spends her time thinking about the future of law and the future of arbitration and mediation and the future of dispute resolution in the broader context. And so the AAA, given how long we've worked there, and a lot of people have been there for decades, it feels like a startup right now. You walk around and there's ideas on walls. There are meetings taking place where people are talking about ideas, innovations, how to prioritize, which ones we want to do. Some are simple, some are a simple aspect of our case management process that we want to modify. Others are big, huge deals that would change the organization as we know it, right? So that's what it's like right now. We're really trying to be thoughtful and intentional about what we're doing. And we're doing that because we feel like, as I say, there's a lot of change going on in our world. I would say that legal practice, the ADR practice, what arbitrators and mediators are doing today is really not so much different from what they were doing 3, 4, 5 years ago. But we're starting to see the impact of it. And I'm putting aside the pandemic virtual hearing issues that I was discussing. It is still largely a forum where parties present their evidence, they do all the research, they do the briefing, right? And there's sort of the equivalent of motion practice if it's a domestic arbitration. And, it's still a lot cheaper and faster than litigation, but it is it looks similar. We think that might change, and we want to stay on top of it. We recently just went through our process of revising our mission, vision, and values. So these are our core statements. This is about how we think about ourselves. And we've now emphasized the need not just to help parties resolve disputes. That's always where we were, is that we wanted to be there for parties who had a dispute and they needed to know where they could go to resolve it. And we were there for them, right? They wrote the AAA, and we want to start thinking about how we can help parties prevent disputes, how we can help parties before they even get to the point where they need to call the AAA to administer their arbitration or mediation, that we get to a point where, in fact, we're maybe, again, we're figuring this out, training, programs, ombud services, and the like. But that's where we want to be as well. Our vision has changed to have an additional focus on making conflict resolution available to everybody. Right now, we are the primary provider for commercial arbitrations in the United States, and we'd like to think the world. But there are a lot of communities, there's a lot of conflict in areas where they don't really do business disputes. They might relate to family disputes or community disputes. We don't operate in that area. And so I'll say a word more about that, but I want to highlight how that changed. And then, of course, our values. I'm happy to say that those that phone is not here. I think the phone is from somebody online. And I don't have access to those master controls. So if somebody can mute everybody else, that might be helpful. I'm doing. So again, with values, look, we want to lead with integrity. We want to provide exceptional service. We want to solve problems. And most importantly, we need to embrace differences. Is there a CLE?
Oh, right. I'm supposed to remind the speaker, and here the speaker reminded me, the people who are online, you need to indicate your participation by accepting 3 code words that Eric will give. I've sent everybody a link to the form that you can fill out. Just write these 3 code words down. And then when we're finished, you can bring that form up, fill it in, and you'll get your CLE. So can you treat us with the first code word? You can't. You haven't thought it through.
It's whatever I want it to be.
You absolutely, it's anything you want it to be.
Right? Justice.
Justice. I thought you were in private arbitration. Okay, justice. There, you just walked into the first question that I'm going to have. What's the relationship between justice and arbitration? But there you go. First code word is justice.
Okay. And there is this question, must ADR itself be mindful in its zesty change that it doesn't throw the baby out with the bathwater? What guardrails are in your special focus on that issue? So absolutely. Yeah, you can really mess things up pretty easily by just tearing it down, right? And throwing it all out and starting over. And that is not our intent. We're really good at administering just about any type of dispute you might have in the world. But as I say, the way it's been done is largely been the same for a long time. So we're not looking to, as I say, throw it out. But we think that there are a lot of tools, and in terms of guardrails, there's these basic concepts will apply regardless of the technology that's applied in a particular matter. Self-determination, the process has to have integrity, the decision maker, them or itself, must be neutral, impartial, independent. The participants need to understand who that decision maker is and what prior experience and expertise they're bringing into that role. I think those are, neutrality is just a fundamental key aspect of that that can't change regardless of what other changes are going to happen in the process. In terms of cases themselves, I also would say that I'm talking about case filings. It has been also a busy year, and a few areas in particular. Case filings are strong; they're healthy. When a case is filed with a AAA, it's most likely on average from a contract that was entered into 2 years prior. That's your pipeline. And, from a business perspective, it can make it very hard to plan for the future because we don't know what's going to come in tomorrow or in a month or in 2 months. And we might get involved in an initiative with a particular industry, and all of a sudden, 5 years later, there's all these case filings. You just don't know. But that's on average what we're talking about. There's huge variations. Sometimes we'll get a case 2 days after the contract was entered into. Sometimes it's a contract from the 50s, literally. But case numbers are strong. And, some areas in particular, I think maybe it's a sign of the times, healthcare payer-provider disputes. So these are not disputes where there's a doctor-patient relationship involved. As a protocol matter, we don't administer those types of disputes. We don't administer malpractice disputes. These are disputes between a physician, perhaps, or a group of physicians and a hospital or a carrier, right? It's about reimbursement. And we know, heard what's happening in that field, and it's a challenge. And one of the things that results are frequent and sometimes significant disputes about payment and reimbursement. For a number of years, that caseload has increased, and arbitration is very, we've got special rules for that. We've got a special roster. The parties really like it. The alternative litigating can be a challenge because, of course, you're going to get a judge who may be fantastic and knowledgeable, but you may get a judge that doesn't know anything about this area. It's one of the primary benefits. Software and systems development. These cases in the commercial area are up also, probably 20% or so. These are not vetted numbers, but I'm giving you a general idea about where we've seen some real change. So again, that probably doesn't seem too surprising. I don't know how many people here have or online have been involved in a software development project, but just dealing with technology within our own organization, it's like construction, where things are just usually about 30% more expensive than they're supposed to be, and they take about a third longer than they're supposed to be. They're literally like construction projects, and there's a lot of that work going on, and so you'd expect those cases to increase. Asset purchase agreements, about 20% increase, and then construction is very busy. New homeowner disputes, people that buy a home and there is, allegedly something wrong with it. The roof doesn't, it's not just that it's leaking. It's, there's a systematic problem with the construction. And again, arbitration has really grown to be a popular way of resolving the disputes because parties don't necessarily want to be litigating. It's very expensive for homeowners on the one hand, and home builders like the expertise they can get from a roster of arbitrators that know a little bit more about that. Industrial construction disputes. These are, think about big sort of energy projects, potentially wind farms, those types of things, multi-million-dollar projects that likely last over the course of a number of years, and construction partnerships. Those are all up. So, big components of both our commercial and construction caseloads are up. International has certain hotspots that are busy. Internationally, it's interesting. It's really not just the ICDR, but if you look at all the international arbitral institutions, last year we had about a 10% increase. But over the course of the past few years, institutions have been reporting that case filings are flat. I think they're reporting this year they're up. We'll see at the end of the year. Everybody sort of reports out at the same time. But people internationally that are engaging in deals don't seem to have been as willing over the past 3 years to run in and file demands for arbitration. There's still plenty of cases going on, but it did sort of temper in a way that we didn't see internationally. Again, that's a little bit of a snapshot. At the end of each year, we do a pretty thorough scrubbing of our caseload because we know everybody wants to know what those trends look like, and it's important that we know it as well. Employment and consumer cases, those vary widely from year to year. This year, actually, the number of cases is down a little bit. It's a little deceiving when you just look at the numbers themselves, because in some years you might have a group of filings that has hundreds of individual parties. This is a trend that's become somewhat known as mass arbitration. It's a topic in and of itself. I'm happy to talk about it if people want, but that is a reason for significant fluctuation sometimes in those areas from year to year. So we want to make sure that our service delivery, as I say, is agile, it's moving quickly, it's efficient. We're doing things like reconsidering all of our intake processes, automating some of that, not just to automate, but to make it easier for parties. We're also engaged in a rule revision process, which one of the first things I was assigned to do when I became a lawyer at the AAA was to be an observer on the revisions to the amendments to the revised Uniform Arbitration Act. And they would send us off to a hotel room, usually over, it would start on a Friday and it would end on Monday morning. So, and it would be off of a highway in a part of the world where they get the cheapest hotel rooms. And, this was literally a negotiation about amending an arbitration statute. It's about as dry as you can get. Our rules revision process, we're also trying to make a little bit more agile and quicker and in more real time. Historically, the way that's worked is that, over a course of 5 years, maybe, we'll collect ideas or there'll be legal developments, and we'll amend our rules to make sure that they are current and they work well. We're speeding that up, but in the coming year, we're going to have a pretty significant revision to our construction rules overall. We're looking at actually appellate procedures for consumer disputes. I'm personally hesitant to do that because, if consumers are arbitrating their dispute and they prevail or lose, I suppose I'm just not sure that sort of the promise of finality in the process is going to be maintained when a business writes in an appellate procedure that could be time consuming and of course costly. But we're going to take that on. We will come up with a set of rules that we think work and that are fair to individuals. But also, if businesses are going to be writing these clauses in that require appellate procedures, then we will have to address that as well. So, a number of rule revision processes. I talked about my first experience with the RUAA, where it was dry and boring, and I'm sort of now an arbitration wonk. I don't dread those revisions as much as I may have in my early days. It's always interesting, and again, it's usually driven by a real need that we're hearing from parties, from our arbitrators. Maybe there's a case law development that really makes a revision important. So those are all things that are happening as well. And then we want to focus on having the best arbitrators and mediators that we possibly can. So again, it's really about developing a culture of innovation and an organization that is almost 100 years old. And I think we're off to a good start. So that's just a little bit. I said I was going to give you a snapshot about what's going on at the AAA and the ICDR. And those are some of the highlights, but it really in some ways just scratches the surface. There's 650 people that are very, very busy throughout the country. And we have an office in Singapore as well. Okay, the other topic that I want to talk about and perhaps hear from some of you is on the issue of AI and technology and what this is going to mean to all of us. I'm not going to talk about how it might be used generally, but I'm going to give some thoughts about how this new technology might make the arbitration process different and hopefully better. I want to say at the outset, we are very clear that we view AI as an advancement, an ability, a tool that can be used to improve the process. There's all sorts of concerns, legitimate concerns about it. But overall, it's going to be a tool that will make the process faster and therefore probably more economical. And it really may provide some access to justice for people that don't have it. So again, think about a consumer in an arbitration. It's tremendous how much information and advice you can get about how to present your case by using ChatGPT. I mean, ChatGPT is one of them. Who knows what's going to be the primary one in 6 months or 2 years or 5 years, right? But there's going to be some form of this tool that will be available, and it will become more trustworthy, and people will be able to use this. It doesn't mean that they're not advocating for themselves. It's going to be a tool, and it's going to provide at least a little bit of democratization to the process. That's not just for arbitration. That would be for litigation as well. But again, our view is at the outset, we view this as a technology that, a lot of my hearing is, oh, we're going to have to embrace it. We have to sort of, you can't avoid the inevitable. We view this as something that we should embrace. And again, that is a positive, both for us institutionally and for everybody else that is in the process. And frankly, we want to lead in this area. We think we're in the best position to do that because of the scope of cases we handle and the number of cases we handle and the staff we have really, really committed. So one of the first things that we did is issue guidance. We drafted guidance and we issued it in Police about generative AI. So again, ChatGPT is one of these, but it came out, people were talking about it, and we wanted to make sure at least our staff knew what they should and shouldn't do about it. But the first thing we said to them was, we're encouraging you to use it. We want you to understand how people use it in their lives and where it can be helpful and where it's useless, right? People just need to know how to use it. It's really not like, it's really, in some ways it's like entering a Google search, but it's really different, right? Google is not going to summarize a document for you, but these other things will. And we specified, you can use it to sort of create drafts of social media. Again, it's still got to be your information. I'll get to confidentiality in a second. Draft summaries of articles, not parties' articles, not parties' briefs, but if you're curious about what an article says and you don't have time to go through a 50-page law review, creating scripts, drafting non-case related communications. And again, we want parties to think about it. Use it in the same way that you would use a search engine generally. But we also wanted to be very explicit about what we see the risks as, or are, what they are. And one thing we're doing is we actually created a committee very quickly when this whole thing broke. We got a group of people together, and they're the people that are supposed to be collecting and are collecting information about where this technology is being used by staff. This is all sort of self-reported. We want people to be honest, and where it works and where it doesn't. And we're already seeing over the course of just a few months that there's a dramatic change as people adopt this technology into their work and into their lives. But we're also very, very explicit that nobody under any circumstances should be taking any material from the parties or even from us, whether it's a business plan or whether it's something proprietary, or if it contains one iota of personal information, staff cannot be and should not be uploading that. Information about our arbitrators. I mean, some of the arbitrators that might be joining us today, you'd probably like it if your name was entered repeatedly into the database that ChatGPT is drawing from for its own training purposes. And it's interesting, you know, on a number of occasions, I've just asked it for a list of arbitrators for a very specific dispute in a very specific city to see what it comes up with, because, you know, I know some of that. I can tell you it's really not there right now, but will it be eventually? Maybe. But we don't want our staff putting information into the system that might divulge information about our panel members. Business activities, intellectual property, it's all out of bounds. We don't want our staff doing that. We want them to use it responsibly. You know, with a code of ethics, we don't want it used for materials that might be defamatory or they're used to insult others. Certainly not to hurt other staff. We don't want it to be used in a way that would ever be where we could be accused of impacting our own impartiality or independence. We do have some decision-making functions in cases. Mostly people think of arbitrators as doing that, but whether a case meets the filing requirements, sometimes those are very hard-fought disputes. Whether an arbitrator should remain on the roster, I should say, on a particular case or not because of a conflict of interest. That's another issue we have to decide. We don't want staff entering scenarios into a tool and asking it what it thinks. That might be coming one day, and maybe that's our large language model. But if we do that, the party's going to know about it, and they're going to have their own input. Again, purely futuristic. I'm not saying that's in the works right now. But we do want to make clear that staff can't do that. And ultimately, and this goes for arbitrators too, arbitrators and staff, you are responsible for their work product. It's your work product. And regardless of whether you use Westlaw, whether you use ChatGPT, Bard, whatever you're writing, it's attributable to you. And that's a critical piece of information. We had an interesting debate about attribution. I don't know if this has come up here. I'm sort of curious. But if you use ChatGPT to write something and it writes 60% of your content, and it's something that is, I don't know, going to be published somewhere, do you have to give attribution to ChatGPT? I don't have the answer to that. Something to think about. But what we said was, at least for now, giving attribution to ChatGPT is probably not going to improve what people think necessarily about the article. I guess maybe some databases they would, but it might hurt it. But I've heard very differing views on this, and I think it's going to change over time. We also issue guidance to arbitrators, and again, if there's anybody out there and you haven't seen these, you will be getting it soon. For arbitrators, they're not our employees. These are people that are on our roster. We've identified them. And frankly, we don't have the same control. Many are members of their own firm. They might be members of a large firm that has their own policy that might be different. But we did issue guidance, and we want arbitrators to be cognizant of a lot of the issues. But the first thing, again, is we want to encourage members of our roster to understand this technology and how it works and how it's going to be adapted in everyday life. But in terms of the limitations, what we did, we went to our code of ethics for arbitrators and commercial disputes, it's an old document in relative terms, but it still has concepts that apply even to this new technology. So regarding maintaining confidentiality, and arbitrators are responsible for maintaining the confidentiality proceedings. They're responsible in our rules for also maintaining the confidentiality of any hearings. And so they really need to understand what the impact is of any of them entering case data or briefs into some sort of tool that might help them with the case, but where the information that they've entered might possibly be spit out at some point in time. That is a really critical concern of ours, and we want arbitrators to be concerned in the same way. The issue of competence comes up. The research that's being done, it's really only as good as the database it's being trained on. We want arbitrators to be fair. We don't want them to use this technology without the parties being aware. Again, we don't want it to be cumbersome or give the wrong impression, but if there's an arbitrator who's using a legal tool that's new and that they might be using to analyze parties' information, we'd probably, if it's something that is out of the ordinary, we'd really want them to get the parties' consent. But in any case, we want them to err on the side of disclosure. And we've actually seen some arbitrators that have standard disclosures now saying, I use this AI tool, sort of fill in the blank. I do not use it. I do not enter party information. I do not use it to draft, right? And please ask me if you have any questions about it. And then the last issue, which again is probably one of the second most important, one is confidentiality. It's a prohibition really on the a delegation of decision-making. Again, this is in Code of Ethics for Arbitration of Commercial Disputes, Canon 5. Arbitrators cannot delegate their decision-making function. And if they're doing it to a generative AI model, then they're really breaching their ethical responsibilities. So those are the confidentiality, delegation, and sort of competence in the tools that you're using, we think are the main ethical issues where arbitrators and mediators need guidance. This is addressed to arbitrators in particular. But I also think both of these documents in a year are going to be totally different. They'll probably need to be updated, and we're going to have to reconsider what the expectations are about the use of these tools. Has it changed? Have some become more prevalent and the like? So that is our approach to AI specifically. Peter, you have a question? Second code? Second code is AAA. Can it be a...
Sure, why not? Can I ask a question before you go on?
Yep.
A lot of disturbing, I guess, to me, disturbing news articles and opinions and stuff have been spread over the last 5 or 10 years, undermining the integrity of arbitration, particularly arbitration of consumer or nursing home or sometimes employment disputes. Do you find, from your perspective, do you see in fact a undermining of confidence in users of arbitration, or people who associate arbitration with unfair procedures or outcomes that they don't trust?
I do. I would break it down though, because at the beginning of this conversation, I talked about how people come to us with their commercial disputes for the most part. I mean, they're interesting, they're fascinating, but when it gets right down to it, they are commercial disputes plus employment and consumer. Most consumer disputes have a commercial aspect to it. I was overcharged. This product didn't work. They're imposing a tax on all their customers that is misrepresenting what it really is, right? It's those types of things. I'm not saying they're not critical, but they, to people involved, but they involve a smaller amount of money. The concerns that exist, they still exist in a significant way. I was going to mention this with regard to legislation. and maybe I'll just take this up now because it answers your question, but there has been arbitration that's been legislation that's been introduced for decades that would amend the FAA to eliminate the enforceability of consumer employment disputes. It's just a perennial bill that's introduced. And there was an amendment to the FAA in the employment context, the Carlson bill, the Gretchen Carlson bill, that makes arbitration agreements unenforceable really at the option of the individual where there's claims or allegations of sexual assault or sexual harassment. So it was like the first area where progress was made. And all those concerns exist, and the undermining, the lack of confidence that I think exists in the arbitration process is still, for those types of disputes, I mean, I'm being honest, I think in the public eye, it's the same as it was 5-7 years ago. There's still suspicion of the process. I think there's some slight incremental change as people go through it more, or maybe they know people that have gone through it more. I can tell you a consumer arbitration award, many of these are very well thought out. Arbitrators take this very seriously, this work very seriously. And the alternative to litigating those is, it's tough. In New York, you might have a small claims court that's an option, but it's an uphill battle. And so as more people sort of go through the process, we've had, again, I think maybe some marginal movement, but in the big picture, no, I think that it's still just as strong. And if there's a change in the composition of Congress, you might see more legislation like that. There's legislation pending right now that would cover veterans. There's a lot of attention on veterans and whether arbitration agreements are binding on them. If they are called to service and they get fired, for example, they should be protected under federal laws, state laws. There's a movement to make those types of arbitration agreements unenforceable as well. So, this is something that I wish we could do a little bit more about, because we feel like the process, in fact, works in many cases very, very well. The alternative is incredibly tough and challenging. Outcomes in court are not better. And then I'm talking about victory, rates of success are not necessarily better in court. And where you do win, of course, you're faced with the likelihood of an appeal that will take another number of years, at least in most courts. So, it is frustrating. I spend a fair amount of time dealing with either inquiries, potential litigation issues involving those areas, consumer and employment arbitration. And many of them are drawn from, I think, a little bit of an unfair suspicion of the process. We would really, in our dream world, people are going to, in consumer and employment, they're going to want to be in that process because they like it better. That's where they want to be. But we're certainly not there yet. I don't know if that is a specific answer to your question, but okay. A little bit of a diversion, just a couple other things on technology that we're working on. One is we've established something called the AAAI lab. It's AAAI. It's a little play there. AAA is our acronym, and then the I for AI lab. This is going to be launched in a more public way at the end of the month. This is essentially, what should I call it? At this point, almost like a little mini think tank within the organization, but it's going to get bigger. So we want this group to work on policy guidance for anybody. It could be advocates, could be arbitrators, could be ourselves. We're looking at this expansively. We want to offer webinars. we want to maybe, I don't know, we're developing it. We're actually right now developing a AI, artificial intelligence clause builder. You can, type in provide an arbitration clause, dispute resolution clause for a case in New York involving IP, right? And it will draft it for you. We currently have sort of a mechanical process for that online, but that's an example of something that we are going to be doing. That'll probably be launched in the first quarter of next year. We want to provide direction and support on how AI can assist in the process. We're going to have town halls. We're talking about collaboration with other organizations. Also on the technology front, we've incorporated cybersecurity as a requirement into our panel standards of responsibility, and the like. So that's actually that's a fun thing to be part of right now, except for the fact that it's the road is wide open and you don't know where you're traveling to. But we want to make sure that we have a leading voice there. All right, I touched on legislation, and the last piece I want to talk about is the foundation, AAA ICDR Foundation. And I have a couple slides for this, and I just need 15 seconds of help to get those.
Jack, can you turn on the screen? Yeah.
Okay. A few words about the AAA ICDR Foundation. So we established this in 2015. It's a separate, we're not-for-profit. AAA is not-for-profit. We established a separate not-for-profit as a foundation. And we wanted independence. We didn't know where funding was going to come from at that point. But there were a lot of areas where some support was needed in dispute resolution, different types of dispute resolution that we weren't traditionally engaged in. And so since then, it's really been a great, very successful part of who we are as an organization. Although its mission aligns with the mission of the AAA and ICDR, it does carry out a function that is really, really critical, but different. So the foundation's mission is to support the prevention and resolution of conflicts by expanding access to alternative dispute resolution. If you look on this left-hand column, it talks about our priorities: preventing and reducing violence, bridging community conflict, and supporting diversity, equity, and inclusion. And we're really trying to focus. One of the problems with the foundation is you'll get a million, grant proposals. You get 100. We had 100, and you got to have some organizing principles, and these are the ones that we focused on. Probably be the same for a couple of years, but they might change in the future. And in terms of programs themselves, we give out money in 4 different ways. One is through an annual grant cycle. So we just finished one, from say, I think June to September, we accept proposals, and then September we evaluate. Early in the next year, we actually decide the ones we're going to do. So those, that's the typical annual grant cycle way of doing it. It's once a year, but we also have a few other ways. Actually, and just in terms of impact, I just want to point out this almost $8.5 million we've given in funding since 2005, and we actually have a little bit saved up that we are working on right now as well. We have a total funding of $13.5 million, and we've funded 150 projects to date. So just in terms of how we do it, I mentioned the annual grant cycle. We'll also have on occasion rapid response grants. These are, there have been some really incendiary issues, conflicts that have come up where in certain communities, and we've funded sort of some like on the spot crisis counseling and the like. So we've done that about 12 or so times. They're generally smaller amounts, but it's a way for us to be much more responsive to in situations where it's needed. Diversity scholarships, we're really excited about this effort. 72 diversity scholarship awards have been given by the foundation, and they can be done in two ways. One is $2,000 either for a degree related program, law students, right? People that need the money, and $2,000 isn't going to pay your tuition, certainly, but it's $2,000 if you really need it. It's been very helpful to some. And then we have diversity scholarships with Howard University and North Carolina Central Law School. These are designated schools where $50,000 a year are allocated to students that are selected by the schools themselves. Actually, this is just a little bit more detail on the diversity scholarships. So we've given away, $500,000 in connection with this effort. And the average award for the two schools that I mentioned is about $25,000. For those folks, it's a really significant impact. To give you an idea about the grantees and the types of entities that we are working with and funding, one is Cure Violence Global. You'll see the grant amount is over $500,000. It's purposeful. We want to give to organizations where we're really making an impact. Smaller numbers of grants in recent years, but in perhaps larger amounts, because we want to give to efforts that are sustainable and that are having a measurable impact. And Cure Violence helps communities implement violence prevention programs. Think about people sort of on the front line that are facing a lot of other people. It's not police necessarily, but public workers and others who are put a little bit into the line of fire because of the nature of their work. The National Institute of Civil Discourse is what it sounds like. It helps people with differing views get along a little bit better. We gave this grant a little while ago, and we could certainly use a little bit more of that in the world. I hope that model works. The O'Connor Institute is another one, again, relatively large amount, but developing a toolkit to develop an online destination where also people can learn themselves about how to address that type of conflict. The Dayton Mediation Center is just a fantastic program. Think about calling 911. All the people that call 911, but they really don't have an emergency. They've got an issue because their neighbors just driving them crazy and they can't get them to stop whatever they're doing, right? It could be music, could be that they keep on throwing garbage over the fence, whatever it is. But these things get really, really tough. A lot of 911 calls are sort of versions of that. And there's a team of mediators, and they go out and they meet with the people that are in crisis, and they resolve it. It's amazing. That's the type of thing that we're really excited to see. And again, another summary. And that takes me to the end. And I now can't see if there are questions because the slides are up here. Let's do it. Okay, do we need the last?
Yeah, I think the last code.
It's foundation.
Can I ask another question?
Sure.
I track the Federal Judicial Center statistics about the number of terminated cases that terminate at different times, and very few of them. Now, for several years, I've noticed that less than 1% of them, of cases that are terminated in federal courts, are terminated at trial. Do most of the arbitrations that are filed with the AAA go to hearing and terminate because of an award?
That's a really good question. And I wouldn't say most do. International cases is about 40%. 40% of the cases that are filed go to an award. Employment cases are more likely to settle. Commercial cases, maybe 40 to 50%. And we've actually heard about some law firms that have said in their recruiting, they talk about their active arbitration practice because you actually get to present a case to a conclusion, to a decision maker. Whereas in litigation, it's a lot less common that you get to do that. I'm not saying that going all the way to the end is necessarily great, but the comparison there is pretty stark. Many more cases that are filed in arbitration are resolved through an arbitrator's award, as opposed to cases that are litigated as a percentage, right? It's a very, very small number that are actually doing jury trial.
Also, in the last 5 or 6 years, there's been a seismic change in the way international trade has been affected, especially with counterparties in Russia or counterparties in China. Through the ICDR, have you noticed any differences in cross-border dispute resolution trends that may have some linkage to either embargoes or other political changes in international trade?
So, not really. I mean, there are exceptions to that, but I talked about case filings a little bit earlier. And I think the view of international practitioners, or just practitioners that are engaged in transactional work involving parties from different countries, they're more concerned. They need international arbitration more than they did 5 years ago, because they're more worried about having to litigate in a foreign jurisdiction that might be hostile, perceived to be hostile. Politically, just because of the politics of where the world is today. And it's not like we just touched base on this for a minute before the program today, but it's not like the entire roster of arbitrators in China changed in the past 5 years. The people that were good and that were being selected then are still the same people now. Same thing at our end, right? The people that are being selected, there are changes. People evolve, they get into that type of work, but the infrastructure hasn't changed. The roster of arbitrators hasn't changed that much. That the types of cases that are being submitted to a dispute sometimes arise out of conflict or sanctions in Russia, right? You can't, if you're making a product and 30% of the materials had come from Russia, and you can't make it anymore, right? Oh, there's a contract dispute. Somebody didn't deliver. Who's going to bear that risk? I mean, so some of that's happening, but in terms of the process itself, again, the general sense is international arbitration is needed more now than it was before, because there's a greater fear of the alternative, of the possibility of having to litigate in a foreign jurisdiction.
There was a question that I just saw online from someone who was interested in learning more about the criteria for the diversity scholarship, and I would extend that to the criteria for any of the grants that are offered by the foundation. How can people learn more about that?
So the grant application process is, it's all online, AAA ICDR Foundation. lot of information about, is there something happening here? A lot of information about the process, the application itself. In terms of I would just say that application again, the main process is through the annual grant cycle, which won't start up again for another 7 months. The diversity scholarships, again, I just think it's you do it. There is an application. You got to fill it out, say what you need it for. We're looking for ADR related educational events, programs, why they're meaningful, why they're important, what the cost is, where they are. So those are the basics.
And our second code was AAA, right? Did we give a third code? I don't remember.
I said foundation, yeah.
Foundation. Foundation was the third CLE code.
It was. Okay, just a couple other comments here, and I'll do these very quickly. One was the second code word, which was AAA, right?
Mm-hmm.
That's it. Sanctions, how does it affect enforcement across borders? There's a question in terms of sanctions, how does it affect enforcement cross borders? And I think maybe that question is getting at if you're a US company and you've got an arbitration that takes place against a Russian company, you win. So how do you enforce that award? How do you go to Russia and enforce this award that was rendered here in Russia? Well, it's going to be tough, but you're supposed to be able to go to the Russian courts and commence an enforcement proceeding, which should be relatively simple. Again, I'd love to be able to say it's not going to be a problem, but it will be a little tough. So there's a lot of discussion about that. There's also a lot of discussion about how, AAA right now, we can't accept money from a Russian party or a Russian law firm. It would be a violation of the Department of Commerce's guidelines, and OFAC would potentially come chasing after us. You get up to the license. There's a process for it. So sanctions is a bit of a barrier potentially. Here, in other parts of the world, some individuals and organizations have been successful essentially getting a blanket license, which means it's sort of a general statement saying you're going to be able to go forward with your arbitration because we need parties to be able to pursue their claims or defend themselves adequately, regardless of whether their counterparty is in a country that's governed by sanctions requirements.
Yeah, I just as a practitioner, I've always taken a layer before that and wondered to myself, who counseled this American commercial entity to enter into a contract with an entity that only had assets in Russia? I mean, the Newark Convention can go only so far, right? That's a risk that they should have been made aware of.
I'll tell you, those are business risks that are hopefully considered before they're made.
Well, I hope so.
I was in Russia, 7 years ago for a massive legal program. And I can tell you, some sanctions were in place already then. And they want to do business.
Right.
They are not political. It is all business.
Right.
So.
Eric, thank you very much for your time, particularly in such a busy week. We very much appreciate your having come. The people online, I hope, and the people in the room will join me in wishing Eric the very best.
Thank you.